3 years ago, okay. And this is a narrow niche category, but according to Texas lawyer, he is a rock star among the legal media.
Lies.
Yes, very wise, exactly.
I said lies.
Oh, well, it's a narrow category, so among the legal media, there's a rock star. He's going to be talking today on Unraveled.
See, the trick is you don't shove the reporters. That's how you get quoted. You don't body slam reporters. That's how you get quoted.
So he's here to talk about Obamacare, religious liberty, and executive power. With that, thank you very much.
Thank you, Anna. I apologize for giving her a hard time. I hear these introductions so much that I like to mix them up every now and then. Can everyone hear me okay? In the back, hear me? Okay, so if you can't hear me, tell me. I'll get a microphone. I don't like one. I don't use them in class. I prefer to have a natural reach. So it's an honor to be here today with the Federal Bar Association in Houston. I know many of you, some of my former students in the room. I'm very happy to see that. A number of judges are in the room. I'm very happy to see them as well. My goal today is to give you an overview of the Affordable Care Act, Obamacare, in 1 hour or less. I can do it, I promise. And this talk is based in large measure on my recent book, Unraveled, Religious Liberty and Executive Power. It's the sequel to my first book, which was Unprecedented, the Constitutional Challenge to Obamacare. And to give you all a preview, the third book will be called Undone. What that book is about, I couldn't tell you yet. No one knows. But this is very much a developing story. It's ongoing. And I think I think it will be to your pleasure. Now, actually, is there a microphone? Because I can't scream this loud the entire time. I'm recognizing. So if there's a mic that I can get, if someone can grab it for me, I would gladly transition. So our story begins with what I call the promise of Obamacare. But the promise, in fact, begins long before President Obama ever took office. Indeed, we have to go all the way back to 1993. Now, for the millennials in the room, if you look at this picture, you won't have any idea what this means. Indeed, before she was a presidential candidate, she was the First Lady, Hillary Clinton. And in one of her first charges in office, President Clinton instructed her to propose some form of health care reform. It was known as the Health Security Act, the HSA. And this would have given virtually every American not quite a right to health care, but an ability to acquire it at a fairly low rate, either through their employer or otherwise. Now, for those of you who weren't alive in 1993, and there probably are people in this room who are not alive yet, this plan did not succeed. Why did it not succeed? For the most part, people didn't want it. There were a series of commercials that aired throughout the early 1990s. How many of you remember these commercials? Okay, good. I see some hands. Now, extra credit. Who remembers the name of the couple? Oh, good. Who said it? Give him an extra lunch. Yeah. Harry and Louise, right? These commercials were aired by the healthcare lobby. See, back then they opposed these sorts of laws. And the premise was you had a ma and pa sitting at the table at home reading this big healthcare reform bill and saying, you know what? I don't want this bill, right? I like my doctor. I like my insurance, and I want to keep my insurance. As a result of these ads, the popularity of what was then known as Hillary Care plummeted significantly. And this taught a fairly important lesson. Oh, my savior. Otherwise, my voice will be shot for the rest of the evening. I'll get the look. This is good. Okay. That way. Oh, okay. All right. Can everyone hear me better now? Oh, there we go. Now we're cooking with gas. So the reason why these commercials were so successful was because they preached a very important message. That for the most part, Americans were happy with their health insurance. You wouldn't hear this if you read a newspaper, but before the ACA, roughly 80% of Americans were very happy with the insurance they had. Now, that number is deceptive, right? People who had insurance liked it. People who didn't have insurance, well, they weren't so happy. Perhaps they couldn't afford it. Perhaps they weren't able to acquire it, or a host of other reasons. But for people who had it, which is the overwhelming majority of people who were employed, they were quite content with it. So a lesson was learned with respect to healthcare reform. If you want to sell the American people on healthcare reform, you have to make them a promise, right? A promise that I'm sure many of you heard over and over again. If you like your plan, you can keep your plan, right? Now, why was this promise such a big deal? This was aimed directly at rebutting the Harry and Louise commercials. The defeat of Hillary Care taught a very valuable lesson, that if you want to reform healthcare, people have to be confident they can keep what they have. So this was a promise that was made over and over and over and over again. And if I can give you a brief lesson on healthcare economics, very brief, I promise. I know lawyers hate math, but this will be simple. There are three factors to consider with health insurance, right? Is it affordable? Is it accessible? That is, are people able to buy it if they want it? And is it comprehensive? That is, what does it cover? You can't have all three. I'll give you two of them. If you want your insurance to be cheap, it won't be very comprehensive, or it won't be available to everyone. If you want your insurance to be available to everyone, it won't be cheap, and it won't be very good. And if you want it to be comprehensive, it's not going to be cheap, right? I'll give you two. I can't give you three. The big lie of the Affordable Care Act was, I'll give you the world, you can keep it, right? We'll take care of these sick people, we'll take care of these poor people, and you'll keep exactly what you have. And it's frankly impossible to accomplish that, right? It can't be done. In fact, what we're seeing now with the debates over the American Health Care Act, the new Republican bill, it would indeed, go back to our chart, reduce costs. And it would indeed make policies less comprehensive. As a result, people will be priced out, right? So you have to balance these three things. And to be honest about it, you'd have to say, well, poor people, sick people, you're probably not going to do so well into this, but everyone else will, right? And that's a message that will go zero politically, but that would be the honest message if they wanted to. The honest message in 2010 would have been, well, we'll make this more expensive so we can care for poor people, and you'll lose the policies you like. That would not have gone well either. No matter, no one paid attention to the details in 2010 like this. They were simply excited. Why? As you may recall, in the 2008 presidential election, the Democrats swept. They had 60 votes in the Senate, 6-0. That was after Al Franken's election, which he won by a few hundred votes, settled. They had 60 votes in the Senate. And it became fairly clear that the Republicans would not go along with this new health care reform proposal. They had no interest in backing it. So Harry Reid, this is before the sunglasses, this was Harry Reid, decided that we would simply go it alone and pass the ACA on a straight party line vote with 60 votes in the Senate. This was a fairly momentous decision, one which we're seeing play out exactly the same today. In the 20th century, all major pieces of social legislation, whether it's Medicare, Medicaid, Social Security, Americans with disability, whatever you want, were all passed with bipartisan support. They all were. This was the first, not the last, but the first major bill of significance, the first social legislation passed straight party line vote. The thinking was, well, let's pass this now, and then once it goes into effect, everyone will simply fall into line and love this law. That isn't quite how things turned out. And there was a certain arrogance, the idea that if we simply pass this now, people will accept it later. And as the hyper-polarized society we see ourselves living in suggests, that was not the case. So what did they actually vote on? This, the Patient Protection and Affordable Care Act of 2010. The bill was nearly 3,000 pages long. It was first introduced in its final form on, beginning of December 2009. Now, an important note, this was never meant to be the final version of the bill. It wasn't. Rather, this was a draft, so to speak. The idea was, let's pass something in the Senate and send it to the House and let Pelosi work her magic. That was always the plan. The Senate bill was never meant to be the final version. The House is where it was at. In fact, that's the exact opposite we have today. Today, the House passed their version of the bill and let the Senate rewrite it. Anyway, so the idea was, let's pass this in the Senate now, send it to the House, and they'll take care of it. The bill passed on a straight party line vote on December 24th, 2009, Christmas Eve. I'll never forget the date. Did anyone read the bill? Of course not. No one actually read the bill. In fact, Senator Max Baucus, the chair of the Finance Committee, said, we don't read bills. We pay people to read bills for us. So for any law students in the room, one day you may grow up to be a person who reads the bill if you're a member of Congress. Good luck to you. But they didn't actually read the bill. Anyway, it passed. Straight party line vote. Why is this significant? The 60th vote in that case was a placeholder. He was a temporary senator. Over the previous summer, Senator Ted Kennedy of Massachusetts, a Democrat, had passed away. The governor appointed someone to sit in that seat temporarily. But about 2 weeks after the vote in the Senate, a special election was held. And this guy, remember him? Yeah. Before he was on Fox News and lost twice in the Senate, he was the winner. Scott Brown, a Republican, won Ted Kennedy's seat in Massachusetts. And he ran on the platform of being the 41st vote to stop Obamacare. 41st. Why is this relevant? Because the Democrats no longer had a 60-vote block. When the bill came back from the House, the Republicans could mount a filibuster and kill Obamacare in its entirety. This was momentous. And for a brief period of time, there was serious discussions of maybe we should abandon healthcare reform, right? Maybe we can't do this, right? As for those of you who paid attention the last 9 years know, that isn't what happened. Indeed, Speaker Pelosi recognized that they would be able to push the bill through with a special approach to passing laws that we know about now called budget reconciliation. Yes, all this stuff that's relevant now began 8 years ago. Now, what is budget reconciliation? Simply put, it's a way of avoiding the filibuster, right? Usually in the Senate, to do anything, you need 60 votes to invoke what's called cloture. But there's an exception to that rule. If there's a budgetary matter, something that's affecting revenue, you can bypass the reconciliation process and pass it with only 51. In fact, that's exactly how the Senate will pass the Obamacare repeal. In fact, the magic number is 50, not even 51, because Mike Pence will cast a tie-breaking vote. Can you imagine? Obamacare will be repealed with the vice president casting the tie-breaking vote. Remarkable stuff. But going back to 2009 and 2010, they said we will use this budget reconciliation process to pass the bill without it going back for a full Senate vote. Speaker Boehner at the time had very little to do to stop it, other than put huge stacks of paper in front of him to illustrate its length, but they simply lacked the votes. We go to March 23rd, 2010. This was the final vote in the House of Representatives to approve the Affordable Care Act. And I want to focus on these numbers, right? 219 yay. Does anyone know how many votes the AHCA had like last week? 219. So the same number of votes that were used to pass the thing in 2010 are now being used to repeal it. Straight party line vote. 0. If I do a quick one, I can make a 0. 0 Republicans backed the bill. And over 34 Democrats bucked the trend as well. Actually, I'm sorry, it's 217-212. I was off by 2 votes, but pretty close. The vote last week was 217-212. I apologize, I stand corrected. But the point's there. It's a very, very, very close vote with very few to spare. The bill went to President Obama's desk in a very famous photograph. He signed it. If you look closely, he has about 23 pens over there, and he signs a different part of his signature with each pen, and he hands them out as souvenirs, right? I have the pen that signed Obamacare into law. And you can see the president smiling, thinking, yes, I did it. I won. Obamacare is the law of the land. Not so fast. Within 9 minutes, I think this is fast, right? Within 9 minutes of the president signing the bill into law, lawsuits were filed across the country challenging the constitutionality of the Affordable Care Act. In fact, Florida, within 9 minutes, they had the ECF notification up. It was fast, my friends. It was drafted in advance. They knew this was coming, but they had it filed real quick. Now, what is the argument concerning the constitutionality of Obamacare? This was the subject of my first book, and the thesis can be summarized with a single vegetable. Broccoli. Yes, everyone remembers broccoli, right? Can the government make you buy broccoli? Now, it's not eating broccoli, right? We'd have some due process problems there. I hate broccoli. Because of this case, I can't eat broccoli anymore. I've actually given up the vegetable. I refuse to eat it. Me and HW, I'm in very good company, right? But Can the government make you buy broccoli? Makes you healthier, lowers your cholesterol maybe, cuts healthcare costs, right? If you buy this product in the aggregate, it will decrease the amount of money we spend on healthcare and make America, never mind, make our healthcare great again, right? So the argument here was the law had what's known as the individual mandate. The individual mandate required people to purchase health insurance, right? Can Congress make you buy a product? This had never been done before. In fact, that's the origin of the title of my book, Unprecedented. Never before had Congress made you engage in a commercial transaction. Once you buy something, Congress can regulate the heck out of it, right? But before you buy it, before you're in the stream of commerce, law students, that's where it comes from, before you're in the stream of commerce, right? Can they regulate you then under their commerce and necessary and proper authorities? Now, most law professors scoffed at this idea. They laughed, said it's ridiculous. Healthcare is a multi-billion-dollar industry. Of course, Congress can regulate it. But they didn't see what was right before their eyes was this was not a regulation of activity, economic activity, but it was pushing someone into economic activity, a nudge, as some may call it. So it winds its way through the courts, makes it all the way up to the Supreme Court, and we got 5 votes, but not the right 5 votes. 5 justices ruled that Congress lacks the power under its commerce and necessary and proper clause authority to command you to buy insurance. However, in a decision that every time I teach it, I keep hoping it turns out differently. It doesn't change. Every year it's like, oh, maybe this time we'll get it right. Hasn't happened yet. The chief, hail to the chief, cast the deciding vote to save the Affordable Care Act. Now, let me actually walk you through this so I have sophisticated lawyers in the room. I want you to understand this holding clearly, okay? The chief said Congress cannot regulate this under its commerce authorities because it's not commerce. Nor is it proper under the necessary and proper. They're 2 words. It's not just necessary and proper. That this is an intrusion onto the sovereignty of the states and individual, and that makes it improper. For your law students not in my class, you can stump your professors. They won't even know that part of the opinion, right? People gloss over that. This is actually a very big deal. Stay tuned to the sanctuary debate. That will be coming back for it. But then we get to the taxing power. Now, during the run-up to the ACA, every Democrat in reach for a microphone said, this is not a tax. 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 Why? Who wants to raise taxes? Yet, the minute they get to court, it's like, this is a tax. Okay, fine, right? Do we listen to the president's words, or do we go what's in litigation documents? Well, we have a different standard now. But generally speaking, we go what's in litigation documents, right? See how things turn around. It's very quick. But the court said, this is not a tax. The chief said, this is not a tax. Congress did not enact it as a tax. I won't treat it as a tax. However, enter the saving construction. The Chief Justice decided that because of my duty to save this law as a judge, I'm obligated to find reasons and ways of upholding it, and I will treat the mandate as if it were a tax. Therefore, it's within Congress's taxing power. Now, he didn't say it was a tax, right? Be very clear. It wasn't a tax, but he will treat it as a tax because of certain factors that are irrelevant. With that, there were 5 votes to save the ACA. Yep. Same outcome every time. I keep reading it, keep hoping, but hasn't happened yet. With that, the battle turned to the political sphere with Governor Mitt Romney, who promised to repeal and replace Obamacare. This was perhaps the least credible campaign promise until the wall, perhaps. Simply because he enacted Obamacare as governor. He was the godfather of Obamacare. In fact, during the debate, President Obama called him the godfather of Obamacare because in Massachusetts, as governor, he worked with Ted Kennedy to create a healthcare law with a mandate. Now, you're sophisticated lawyers. You know the difference between a state law and a federal law. No one cares, right? That makes no difference to 99% of the population, except for people in this room, perhaps. With that, President Obama won a 2nd term in office. I would have loved to hear what he and the chief were saying here. Alas, it was not recorded. See, at that point, right, this was where my first book ended. I thought I could stop writing about Obamacare, move on to something more interesting. In fact, one of my colleagues said, oh, don't call it Obamacare. And in 5 years, no one will even use that word anymore. Okay, well, we move on to what I call conscience and contraception, which is where the ACA intersects with religious liberty, a topic I'm sure that's near and dear to many people in this room. So at the time the ACA was being debated, most attention focused on this guy. Who is he? Bart Stupak was a Michigan pro-life Democrat. Yes, they were allowed to exist back then. A Michigan pro-life Democrat. And he opposed the ACA because he feared it may increase funding for abortions. How did President Obama mollify those concerns? With his pen and phone, yes. He signed an executive order saying, we will not change anything. We will not provide any new funding for abortion. Now, as my law students will tell you, what is an executive order worth? Unless there's a nationwide injunction to be had. But usually these are worthless documents, right? They don't mean anything. Indeed, this executive order was sufficient to corral the votes of the pro-life Democrats, and the president now had a majority in the House, right? That 219 vote, the block of those were the pro-life Democrats who joined this. Now, while all attention was focused on this so-called abortion funding, which was not really a big issue, there was another issue simmering underneath. It was a so-called Mikulski Amendment, or the Women's Health Amendment. Okay? This was a provision added to the ACA that almost no one paid attention to at the time, but would spawn significant follow-up litigation. Now, I'm sure you've all heard of the contraceptive mandate. People have heard of this. Now I'm going to stump you. Is there actually in the ACA, the statute, a mandate to pay for birth control? Absolutely not. Does the word contraceptive appear anywhere in the bill Congress voted on? Absolutely not. What word appears? Preventive care for women. Now, what's preventive care, you may ask? Well, if you read the legislative history, for those inclined to do so, may rest in peace, right? For those inclined to do so, people talk about mammograms, pap smears, right? Do I need to go down the list? If you look at the debates, people were talking about things affecting women's health, prevent diseases. But Mikulski is no fool. She was very smart. She said, we will let HHS decide what preventive care means, right? They were kicking the can. They knew exactly what the administration would say. There was no mystery, right? What HHS would say. So the Institute of Medicine, which is this kind of quasi-nonprofit, non-governmental group, compiled a report. They said, we've determined that when Congress says preventive care, Chevron, ambiguous, right? When we determine that the phrase preventive care is ambiguous, deliberately so, we will interpret it. And the agency said, what is preventive care? The full range of birth control. Everything from the morning after pill to Plan B to Ella to the condoms, everything else, right? Family affair, I suppose, not for long. This was nowhere in the legislative history of the law or in the statute. And for those who care about the major question doctrine, this is a major question that Congress ought to rule on, and which, of course, should give no deference to the agencies. This was the subject of my amicus brief, whatever cases, but this was a reg that was adopted. Now, this was a very popular provision for many sections of society. This is an actual commercial put out by the Colorado government agency. And for those in the back who can't read it, I'll read it to you. It says, got insurance, okay? Let's get physical. OMG, that's, oh my God, Judge Jones, right? OMG, that's, he's hot. Let's hope he's as easy to get as his birth control. And you see she's smiling, holding a pack of pills. He's giving, he's put his hands in his pocket. It doesn't leave much to the imagination. So it's awesome, right, to think how this new law covers, right? It's a very good service until you realize who has to pay for it. Nuns. So you see, under this law, as it was originally understood, employers would be covering his and her birth control. Under the original regulations, if you can believe it, the Little Sisters of the Poor, this is an order of nuns who care for the elderly, right? they were deemed insufficiently religious to warrant an exemption from this regulation. Serious. Under the original version of the regulation by the Obama administration, only houses of worship were exempted. Now, if you were a nun who decided not to work at the convent, but instead you want to, help poor people and help elderly, it's a good thing to do. The government said, you are not sufficiently religious because your employees may not share your religious beliefs. Pay for the morning after pill for your staff. This initial reg did not go over very well, as you can imagine. And this began a never-ending series of rulemakings, one after the other after another, where the government said, okay, you guys are in, you guys are out, you guys are in, you guys are out. So eventually, the deal was, okay, little sister of the poor, you don't have to pay for the birth control, but we want you to sign this document. Oh. As a consequence of signing this document, you guys are lawyers, you're amending your plan documents for purposes of ERISA. We're actually inserting this new thing into your plan under ERISA, and as a result, Aetna, Blue Cross, whoever it is, will provide birth control through your policy. So your employees don't need a separate card or anything else. It'll be easy. You don't have to pay for it. Just sign this document. As you can imagine, the nuns were not too keen on signing a document that would result in their healthcare plan being hijacked to provide these devices that they deem utterly inconsistent with church teaching. The Obama administration would not budge on this, and lawsuits were filed challenging these regs on religious liberty grounds. But the first one that came up was actually Hobby Lobby. It's a craft store that's privately owned. Now, I'll tell you a funny story. Whenever for my first 2 books, I actually mailed copies of my books to all 9 justices. Actually 8 with Scalia had already passed, but actually I sent it to Judge Gorsuch at the time, so I did cover myself. He wrote one of the circuit opinions in Hobby Lobby, so I covered my bases. Not all of them, but a lot of the justices mailed letters back saying thank you very much, and I always get those letters framed at Hobby Lobby. So I have this great letter from Justice Sotomayor and Justice Ginsburg framed at Hobby Lobby, which is my little passive-aggressive SCOTUS notary. But I want to move, though, from the legal back to the political for a minute and talk about the perhaps most chaotic portion of the Obamacare saga, which is what I call the shutdown. After the 2012 election, I was pretty sure that the battle to stop Obamacare was pretty much over. I thought, well, you tried and you failed. Let's move on to the next thing. Not so fast. So a lawyer who is no stranger to people in this community, who's now our senator, in fact, you may have heard of him, Ted Cruz, spent the entire summer of 2013 barnstorming up and down the fruited plain, saying we need to defund Obamacare. Now, what was Cruz's strategy? Okay, follow me here. We no longer have funding of the government on a long-term basis. It's always these short-term funding packages. At the time, the funding for the United States government expired on September 30th of 2013, September 30th. Obamacare opened up on October 1st. Oh, so this is Cruz's genius, right? If the funding ends on September 30th and Obamacare opens up on October 1st, if we stop the funding, Obamacare will never quite open up. And this was the pitch, which Cruz and others, Mike Lee as well, another well-known attorney who's now actually in the Senate, that they pitched that we need to defund Obamacare before it starts. Now, not to douse any cold water on our junior senator, the strategy wouldn't work even if it could work. Obamacare is what's called a permanent appropriation. The money is funded regardless of any annual appropriations. Even if the government shut down, Obamacare would have still opened up. Indeed, that's what happened, right? The government shut down, Obamacare chugged along. So this entire plan, even if there were the votes, wouldn't have worked. Now, the hard part is there were not the votes. Senator Cruz, mounted a almost 24-hour filibuster. Now, it wasn't actually a filibuster because there was a vote scheduled the next day. So he couldn't go as long as he wanted. But he was on the Senate floor for nearly 24 hours. Here he is reading a Dr. Seuss book to his 2 young daughters. I thought it was a pretty cute part of it. And if you look closely, for those Texans, he has a Malin Labe Gonzalez pin. Come and take it. which I thought was a very fitting image. If you read my book, I have an entire section on the Battle of Gonzales and all that good stuff. So after 24 hours, Ted Cruz emerged to begin his presidential. I'm sorry, to begin his. Oh, too soon. Anyway, so after Cruz emerged, it didn't work. About a week later, after some fighting with the House, a budget cannot be reached, and we had a shutdown. Now in Texas, we don't really notice government shutdowns. Maybe law clerks, perhaps. I don't. The law clerks, no, they're good. They're solid. So during the shutdown, though, perhaps the most visible symbol was the World War II Memorial in Washington, D.C. If you've never been, it's a beautiful open-air memorial. And one of the most special traditions we have is called the honor flights, where you have these World War II vets who fly to the nation's capital. They get toured around. They take them to the monument. It's a really nice thing if you ever see it by the airport. So you can imagine that morning a group of vets showed up at the World War II Memorial for a trip that had been planned for months, right? And they weren't allowed in. Now, this was an open-air memorial. So what do you think happened? If the shores of Normandy could not stop them, a couple barricades could not stop them either. So these vets with their wheelchairs and everything else carried these barricades across the street and dropped them on the lawn of the White House. So that was a very fitting image. I'm glad they didn't get arrested. But all good things must come to an end. In addition to the government shutdown, which is never popular, we ran into the debt ceiling. Yes, so the Cruz strategy failed on a couple of levels because we ran headlong into the fact that we need to raise the credit limit. Ultimately, the Republicans caved, as they usually do, and they funded everything, right? They funded all of Obamacare, they funded the debt ceiling, they funded the government, and in fact, they lost points. The sequestration, which was in effect to cut spending, they lost that also. So basically, Obama swept and he got virtually everything he wanted. But the government shutdown had the effect of obscuring the unraveling of Obamacare in the form of healthcare.gov. Now, this was a website the government spent, I think, nearly $1 billion trying to build to allow people to sign up for health insurance. Did it work? No, it did not work at all. And this was poor Adrian who became the cover model for healthcare.gov. Truly, indeed, a nightmare. So the problem was the website didn't work. You had these massive bureaucracies, no one talked to each other, and there was this fear that if anyone said, this is not going to work, there will be political retribution. So everyone kept their mouth shut. They didn't say anything. No leaks, right? No leaks. We didn't have those back then, right? No leaks. And everything was like, yeah, we're going, ready to go. And then the launch day, it did not work. Even though this was a simple website, right? Truly a simple website, it nearly derailed the entire ACA. Because if people weren't able to sign up for policies, they would then be subject to a mandate, a penalty that John Roberts told us was really a tax, right? They would have been hit with this fee. And there was a brief period where Obama considered dropping the entire enterprise to try and fix this website, come back next year. Instead, he opted to send in the nerds, right? The so-called tech surge. The tech surge, which was basically 5 guys from Facebook and Google who built the entire website in a month. I'm not exaggerating by much. And the president promised that it will be ready by Thanksgiving of 2013. And indeed it was. And the website was operational. But this led into the next Obamacare crisis, which was the crisis of cancellations. Yes, the promise, keep your plan, was never a promise meant to be kept. Indeed, the lawyers in this room, a series of regulations were issued saying we expect about 12 million people to lose their policies. Right? It was in the Federal Register. So as Obama was saying, keep your plan, in the Federal Register was the real stuff. So again, when the president says one thing and the government says another, we never mind. So these letters were sent out by the millions. The President Obama was called the lie of the year. But after everything, the president was able to get people to enroll. People walk down to the local Obamacare store. I don't know where this is, but somewhere they sell Obamacare by the box, I guess. And in the first year, roughly 8 million people signed up. One note to caveat statistics, the number of people who enroll is not the same number of people who pay for insurance. And there's a significant number of people who never pay their bills because the IRS can't collect, right? And the insurance companies can't collect under Obamacare. So a lot of people never actually pay their bills. They sign up, get this treatment, they walk away, and they sign up next year from someone else. You can't price them in the marketplace. So these numbers are always subject to alternative facts, I suppose, but they're always subject to debate. Let's go back to the law and talk about religious liberty. And I'm sure many of the lawyers and indeed law students should know the case of Employment Division versus Smith. This involved a Native American who was fired from his job. He used peyote. It's a hallucinogenic cactus. He went to the Supreme Court and he asked, can they deny me unemployment benefits, right? Can I be denied benefits because I was exercising my religion? Justice Scalia said, yes, you can, right? We have a neutral law. It bars use of drugs, doesn't single anyone out, so you're okay. So that's the Smith decision, probably one of Scalia's most controversial decisions. But this case yielded a backlash and led to the enactment of a law called the Religious Freedom Restoration Act, RFRA. If you can imagine Democrats and Republicans uniting to sign a law protecting religious liberty, it's unthinkable today. But there you have Bill Clinton, Al Gore, Chuck Schumer, and Orrin Hatch smiling at a bill. Like, I can't even fathom this happening, that they're in the same room. Like, I can't even imagine this. But anyway, different times. What is RFRA? Well, by the name, RFRA tried to restore the state of First Amendment law prior to the Smith decision. What exactly did it do? Well, that's subject to some debate. Actually, a Texas connection. RFRA was declared unconstitutional as applied to the states, right? This was a case of Bernie versus Flores. This was a case not too far from here in Texas. But RFRA still applies to the federal government. Which brings us back to Hobby Lobby. Always bring it back up. Brings us back to Hobby Lobby. Hobby Lobby is a craft store that was founded by David and Barbara Green in their garage, basically. It was a home business that exploded, and they now have stores all over the country. Now, this is a fairly unique business. Even though they have stores all over the place, it's not publicly traded. In fact, it's owned by a husband and wife and a family. Now, this may look like an Easter card, but it's actually photographed the board of directors, right? The family is basically ownership of the entire company through a trust. And what's unique about this is that they all share the same religious beliefs. You'll never get that in a publicly traded company. So it's actually quite unique. And one of the beliefs that they all share is that certain forms of birth control, the morning after pill, Ella, and certain types of IUDs violate their religious liberty. Now, wait a minute. Is anyone forcing Barbara Green to pop the morning after pill? Of course not, right? That's not what's at issue here. The issue is, does it violate their free exercise to make them pay for someone else to use it? And that's not an entirely self-evident question, and this was a subject to extensive litigation, right? Does it make you violate your free exercise to pay for it? Now, we pay for lots of things we may not like. What if you're a Quaker and you're a pacifist? Can you object to paying income tax because it's being used to pay for tanks and guns and bullets? Right? We live in a crowded world where our money is being used in ways we don't like. So what about making people pay for this form of birth control? One of my favorite pastimes is looking at signs outside the Supreme Court. These are good. Protesters always have very unique roles because they have to make a sign that's catchy and gets their message across in a couple words. So this one, if men could get pregnant, birth control would be from gumball machines and be bacon flavored. But in the background, my mom's not ready to be a grandma. That one's there also. This is not a church, it's a craft store, right? This is my favorite. She's dressed up as a pack of birth control pills. I'll give you my absolute favorite one. Family show. What is she holding? Oh, you know. Say it. Oh God, Texas. It's a uterus. Yes, usually at law schools people go, uterus, right? People crocheted uteruses and mailed them to Hobby Lobby's headquarters as a symbol of protest, saying, "Mess with this one, not mine." Oh, there it is. They probably shop for the yarn at Michael's though, or Joann's, I suppose. The pro-lifers, their signs are never quite as good. They simply aren't. I am pro-life, team pro-life. These guys, I think they were off message. But they were actually wearing kilts, but not the real kilts because they had pants on. That does not count as wearing a kilt. It was snowing that day, so I will give them a dispensation. In any event, the Hobby Lobby case was argued at the Supreme Court. Paul Clement argued for the Hobby Lobby. Solicitor General Verrilli argued for the government. And there were a couple of major issues here. The first issue involved Does RFRA protect corporations? Right? Can a corporation exercise religious liberty? This was a redux of the Citizens United bugaboo, right? And on this question, the court actually split 7-2. Only Justices Ginsburg and Sotomayor said corporations can never have religious liberty. Churches are corporations. Kosher butchers are corporations. There are cases involving religious liberty rights of corporations. So this part wasn't that surprising. But the tougher issue was, does it impose a substantial burden on the Hobby Lobby owners to pay for this form of birth control? Here, the court split 5-4, and as always, Justice Kennedy cast the deciding vote. So the court said first that there is a substantial burden to make someone pay for these products they find sinful. But critically, Justice Kennedy said, I'm going to allow Hobby Lobby to prevail because I think that there's another least restrictive way in birth control, right? What happened? Remember that accommodation they gave to the Little Sisters of the Poor? Kennedy said, why don't you give Hobby Lobby the same thing you gave to the Little Sisters of the Poor, an accommodation? And with that, the fifth vote was cast. Does anyone think that actually ended the controversy? No. During the arguments, I think it was Ginsburg or Sotomayor asked Paul Clement, if we gave you the same thing that Little Sisters got, would you be okay with that? And Clement was like, well, I have to check with my client. You know what that means, right? When you say I have to check with my client, yeah, that means no, but you can't say that in the argument. So, of course, Paul Clement knew that question was coming, but they said, oh, we'll check with my clients. You know, I can't give you an answer now. Ruled for Hobby Lobby there. And I think this was the moment that Justice Ginsburg became the diva that she is, a notorious RBG. This was the moment when she achieved that status. A little bit less popular now that the Democrats are in office, so you can't retire to give her seat up for it. But she was pretty popular then. Okay, I'm going to skip the King v. Burwell case only because it's really boring. I don't have enough time. But it's about statutory interpretation. Let's go back to the nuns. Let's finish up with the nuns. So, what's up? I heard murmuring. When I hear murmuring in class, I know something's wrong. So the Little Sisters of the Poor, don't worry, I'll leave time for questions, I promise. The Little Sisters of the Poor, an order of nuns, and they help the elderly. Ooh, someone's dialing away. Ooh. I can go over this. The Little Sisters of the Poor are an order of nuns, and they tend to the elderly. They have homes throughout the United States. And their main objection, their main objection was that they didn't want their plans to be hijacked by the federal government, because the federal government said, sign this piece of paper, and as a result of signing this piece of paper, the insurance company will pay for the drugs, or the government will pay for the drugs through your plan. Believe it or not, a majority of the courts of appeals, including one not too far from here, ruled against the religious claimants. And they argue that it is not a substantial burden to make them sign this piece of paper. Those were the holdings. Only one court of appeals in the 8th Circuit actually ruled for the religious claimants. Oh, it stopped. Good. And it went on appeal to the Supreme Court. It was actually a very special day for me. I was sworn into the SCOTUS bar the day the Little Sisters case was argued. So I was sitting 5 feet away from the justice. You're in the front row right over there. And it was pretty cool seeing all the nuns around, to see the guys in the robes. It was a remarkable sight. The case was argued for the Little Sisters by Noel Francisco, who's the soon-to-be Solicitor General of the United States. And as well as Paul Clement, who argues all these cases as well. The challenger said, this is a violation of religious liberty to make them sign this paper. The government can just pay for the drugs themselves, use a secondary plan, don't use the Little Sisters plan. The government, for Solicitor General, really said, no. If we use a separate plan, it imposes an obstacle to women, right? They have to have a separate card, apply for a separate program. There's a burden there. It's almost like an undue burden. You know about that in this jurisdiction, but it's almost like an undue burden framework, right? After the case was argued, my sense was this is pretty close, right? It was actually shocking. You had 8 justices. Justice Scalia was not on the bench. And Justice Breyer is very idiosyncratic on religion. Look at his Ten Commandments decision. He's very idiosyncratic. And I could see he was really conflicted on this because he's like, well, I want women to have birth control, but I also don't want to hurt these little nuns. Like, you could actually see it. He was tormented. He has these soliloquies where he just, like Hamlet, he goes on and talks about what's bothering him in court, and he goes on for minutes at a time. But you can see he was being bothered. After the argument, the Little Sisters came out. They had their press conference. They'd actually busted in all the little Catholic school girls for the sidewalk. It was an amazing sight. But then something crazy happened, right? About a week later, the justices issued an order for supplemental briefing. Now, if you're lawyers and you get asked for supplemental briefing, that means something's up, that you didn't do something right, or the judge thought something you did. That's somewhat rare in the lower courts, right? It happens, but not too often. It never happens in the Supreme Court. Like, in the last 30 years, it's happened maybe 15 or 20 times. It's not common. And the court goes, well, can you guys think of something else, right? I know you've been litigating this for nearly 3 years. Is there some other way that you can get these women access to birth control and protect the free exercise of the nuns? Is there something you could do? So there was more briefing. And the government said, well, maybe we can do this and maybe we can do that, but yeah, no, we can't. What was the divide? The challenger said, give them a separate plan. If you make the separate plan for birth control that we don't have to sign anything, we're okay with that. And the Obama administration said, no, 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 you can't have a separate plan because if there's a separate plan, it burdens the women. It's a burden on them. How did the justices resolve this dispute? Just kidding, they didn't. They punted. They said, well, we have this new pleading that says you can work this case out. So go back down to the lower courts, burden these Article III inferior judges, and maybe they can figure it out. Now, no one thought this was really a request for guidance in the lower courts. This was a punt. There were 8 justices, and the presidential election was 4 months away. I'm sure they thought, well, in a couple months, we'll have an election, and maybe we'll have a justice appointed who'll be the 5th vote, one way or the other. Let's send this back down to the lower courts. The nuns celebrated, they cheered, they didn't lose, right? For once, religious liberty didn't lose in the court. It's increasingly rare. But everyone said, okay, we're going to be okay until Hillary wins, and then Justice Garland will rule against the nuns. Actually, he would recuse. People don't realize this. He voted on a contraceptive mandate case in the DC Circuit, so they still have 8. I had that one tucked away when I needed to. But Hillary will win, whatever. That's not what happened, right? The election happened. Now is a very different position. The people of HHS are the people who used to be arguing for the Little Sisters. And they are now working to put out an accommodation for the benefit of the nuns and these other groups. What exactly that accommodation is, we don't know yet. They've asked for several extensions from the various courts of appeals. But I expect at some point they'll issue a waiver that will make the Little Sisters happy. And then they'll be sued by Planned Parenthood and other groups saying that's violating women's rights, and that'll be the next phase of litigation for my 3rd book. But for now, I want to close with a discussion of where are we headed, right? What is the trajectory of the current debate in the House of Representatives and the Senate? Now, the CBO estimate came out yesterday. Here's the very simple way of explaining this. The reason why Obamacare covered so many people as it did was because it was very expensive, and it shifted costs onto healthy people. There's no other way to explain it. Sick people benefited by making it more expensive for healthy people. That's a moral question, which we can all debate, right? Should sick people pay more by virtue of their genetic lottery, right? It's a philosophical question, maybe yes, maybe no. If the Republicans insist on the line that we will not make things worse for sick people, they're lying, right? It can't be done. If they say, yes, this will make it cheaper for everyone, but probably worse for sick people, that will be an honest way of doing it and also suicide. Now, the bill that they drafted, and I don't say this lightly, is actually worse than Obamacare. It basically pushes us even closer to the death spiral because of the way the law is structured. And I fear, sincerely so, that this will be the last gasp before single payer. It will come sooner or later. We'll have some sort of national health care once the next election happens. But this bill is not a very good idea. I don't think it's okay to simply pass something for the sake of passing it. I think it's a stupid approach. And if indeed this is passed on a 50-vote block with the VP casting a tie-breaking vote, it can be repealed on the same 50-vote block in like, what, 2.5 years? Three years, whatever it is. So as always, be careful what you wish for, because things usually come back to haunt you on the other side. Thank you so much for your attention. I welcome questions, and I appreciate your kindness. Thank you. Questions? Oh, come on. Yes, sir.
One part of the Supreme Court's decision, the first one on the Affordable Care Act, the first one had to do with the ability of the states to back out of Medicaid. Could you explain that issue a little bit, because it seems to be front and center a lot of legislators now.
So I can do the Tony Robbins walk around. So the way the Affordable Care Act operated was it basically told states you have a choice. You can either expand the number of people you have on Medicaid, or we'll bankrupt you, right? There was a letter in the record that said to Arizona, if you fail to expand your Medicaid rolls, we will take away all of your Medicaid funding. It was like $12 billion. It would basically bankrupt the state. Is that a choice? Not really. And by a vote of 7-2, the Supreme Court invalidated that provision, saying it was coercive. You may remember a case from law school called South Dakota v. Dole about highway funding. They said, look, you can't threaten to take away so much money that's too much. Not proper, right? You can't do that. So as a result, the chief rewrote the ACA and said, instead of striking down Medicaid provisions, which is correct, he said, we'll give you a choice, right? States, you can opt in to Medicaid. Then you're stuck by these conditions. That created a very anomalous situation where roughly half the states in the union, mostly Republican governors, right, said no way, no how, no Obamacare. And it creates this weird situation. So go to Texarkana, right, our favorite border town. If you're on the Arkansas side, you'll get Medicaid, right, if you're at a certain income level. If you have the same income level on the Texas side, you get BOTUS. And here's the even more insidious part. The ACA has subsidies to make health insurance more affordable. But the law didn't countenance putting subsidies for people at that band who should have otherwise been eligible for Medicaid. So there's an entire class of people in Texas who get neither Medicaid nor Obamacare subsidies. It's really like not what the law is designed to do, which is why they should have struck the entire thing down. But this is the world we live in. So now the question is, states that did decide to expand Medicaid, what happens to them with the law? And all the governors from Ohio and Pennsylvania say, no, keep our money. And the Trump budget says, no, we're going to scale this back. This is one where I don't think the president will win because he needs the votes. And you have Portman, and Toomey, and people in expansion states who are not going to back this. But the Medicaid issue that John Roberts and his buddies created still infects this polity today. Other questions? Of course you can.
I don't think I'm going to get involved with it. So actually, until I had read the article about you in the Texas Lawyer, I had never given much thought to what the legal media is. And so my question is the legal media, do you consider it to be partisan, and do you consider yourself to be partisan?
No and no. I mean this sincerely. Reporters are trying to get things right. I sincerely believe that. And the legal press, I think, is a cut above the regular press. Because they're not trying to write 30 opinion pages. They're trying to explain fairly complicated doctrine. Now, we're all human. We're all mortal. We have our priors. We have our dispositions. And we all approach life with certain beliefs. So I think that makes you partisan? No, I think it makes you a human being. And I, among others, I have my beliefs. I have my thoughts on the ACA and the constitutionality thereof. But I don't think it all has to be political. There was a lot of political commentary about the Obamacare, and I try to shy away from it, keep it grounded to law as much as I can. For brief writers, here's one tip to use when you're writing a book: no adjectives, no adverbs. Describe stuff with nouns. A writer gave that tip to me years ago. But when you use an adjective, it's lazy because you don't explain why, right? Because the opinion is unpersuasive. Well, why is it unpersuasive, right? Use nouns, not adjectives. And adverbs are even worse, right? It was poorly reasonable, but why, right? So you can hide behind it. So I try to use certain crutches to minimize the effect of my own disposition. But
I'm sure it comes out. I filed several amicus briefs in this case with Little Sisters. I filed briefs in the King v. Burwell case. I will file a brief if the House v. Burwell case ever goes up. Lots of amicus practice, but I don't think it's a partisan affair. Yes. You want the mic?
No, that's okay. What do you think, because this is all, at least the contraceptive mandate litigation, is all over regulation. With Justice Gorsuch on the bench, whose jurisprudence is decidedly skeptical towards some of our administrative deference doctrine, how do you see that playing out either in the strategies that litigants take, potentially in how the circuit courts are coming out in their opinions as they're taking a look at these again, sort of with an eye to justice on the bench?
Well, it's such a good question. I'll answer your question first by noting that reg's probably not long for this world. That reg will probably be repealed by rulemaking hopefully soon. But I wrote an amicus brief on exactly that issue last year before we had a Justice Gorsuch on the major question doctrine. And for those of you who don't know, read Judge Kavanaugh's dissent in the net neutrality case 1 week or two ago. The court has suggested in a few decisions, Brown and Williams Tobacco, MCI versus AT&T, a few others, that there are certain questions that are so significant that unless Congress specifically says, agency, we want you to regulate this, they can't regulate it. And I argue that decisions affecting religious liberty are such a significant value in our polity that unless there's an actual explicit delegation, the courts are acting ultra vires. I'm sorry, the agency is acting ultra vires. Again, the only word in the statute was preventive care and women. That's it. It said nothing about religious liberty. And I wrote in my brief that they don't have the power to pick and choose, right? Oh, you get it override. You get exemption, you get a waiver, and you get to pay the bill, right? They can't decide religiosity. That's beyond the ken of the Department of Health and Human Services, with all due respect to the people who are there. That's not in their agency expertise. If you want to read more in the Harvard Law Review, the article called Gridlock, I wrote a piece on these Little Sisters case. But yeah, so you're exactly right. This should have been an easy way of resolving the case if Justice Gorsuch was on the bench. But I don't think this regulation will see the light of day. But we will see the major question doctrine in the net neutrality case coming up fairly soon. The court's not on that one. DC Circuit. Other questions? We have time?
Yeah.
Thank you all so much. I'll stick around here if you have questions, and thank you.
Sure. Thank you so much. Oh, thank you.
Pen
You don't have
for
to do
you
that.
to,
You don't have to
you
do
can be
that.
like Obama. You can use it to sign whatever you're going to
That's very considerate. Thank you so much.
Thanks very much for coming.
Oh, my pleasure. My pleasure. Ooh, fancy. Look at this.
It's a moon rock, disguised as a pin.
Do you see that bladder? Judge, I'll see you later tonight.
I look forward to it.
Thank you. Oh, this is fancy. You see, there was actually a funny story. I recently had I do a lot of cable news TV, and I got this earpiece made, like a custom ear mold. And this firm that does it did Neil Armstrong's ear molds 40 years ago. It's a family, father, grandson, son business, and they're in Bel Air. No, yeah, they're in a Bel Air area, and they the same guy, and he had hanging on the wall Neil Armstrong's ear molds.
Gosh,
It's pretty cool.
it's almost like building shoes in London.
They could have put it back.
I appreciate the correction.
My videos. You're not the first person. It would require a slight modification how I structure my class. But people always that. There are other ways of doing it. Yeah, like I told him that. Show him that. Well, here I'll give you a card. I've always Oh yeah. Well, I mean, where do you work? Oh, I'm actually CPA. Right? I'm my own CPA for Galleria. Yeah, so I got involved back in 2014 at National League. I appreciate the keep it up.
We had Charles. We had Charles.